Thank you, Mr President. I rise today to speak against the Conversion Practices Prohibition Bill 2024, and in doing so I indicate that this is a conscience vote for the Liberal Party. I note that the Labor government is ramming this legislation through at a rapid rate. In just one sitting day, the bill was introduced to the House of Assembly, taken through all stages and then received in the Legislative Council and read a first time. Today, the Attorney-General has read his second reading speech. Meanwhile, the government has indicated that it tends for all stages to be completed today. Mr President, I do not understand why the government has thought it appropriate to ram through such legislation, yet when the Honourable Frank Pangello sought to establish a select committee to inquire into gender dysphoria and gender-affirming care, it was reported that the government would not be supporting its establishment. At the time, the Premier, Peter Malinauskas, was reported to have said, and I quote, "I'm not too sure if a parliamentary inquiry that would be hyper-political in nature, that would only seek to perpetuate the culture wars, is the best way to do a medical examination of medical policy." He went on to say, "I would much rather any sort of examination of this to be done in a methodical, policy-based way, based on the science, the best available medical advice," end quote. To my knowledge, Mr President, no such inquiry has been established by the government. Nonetheless, today we see legislation covering this very issue without having allowed this vital conversation through a parliamentary inquiry. By someone who I often hear referred to as apparently a Conservative Premier, this government is trying to control the conversations that people are having around their dinner table. When did we become the police of personal conversations? We talk of small government and less overreach, but this bill is incredible overreach into the personal lives of people in this state. Across the weekend, we saw an article in the Advertiser about individuals who, quote, say they are being subjected to high levels of corrective processes, including brutal coercive practices such as corrective rape, forced marriages and exorcisms. I do query if such behaviour would already be captured by other legislation and how far spread such practices are in South Australia. But to be clear, that behaviour should not be condoned and is not acceptable. However, my concern is that this bill goes beyond what I think would spring to mind for many people when they hear of the term conversion therapy or conversion practices. This bill defines conversion practice as practice, treatment or sustained effort that consists of more than one event or occurs on more than one occasion that is directed to an individual on the basis of the individual's sexual orientation or gender identity and directed to changing or suppressing the individual's sexual orientation or gender identity. My query is, what is the threshold of suppressing an individual's gender identity and sexual orientation? Is it refusing a man who identifies as a woman to participate in women's sport or use a woman's bathroom? Is it refusing or neglecting to use someone's preferred pronouns on multiple occasions? I'm not sure when it became controversial to say that men should not participate in women's sport and that it poses a risk to female players for men to do so. Not to mention the fact that it is not fair as men are biologically built differently and therefore have an advantage, or that many women feel unsafe at the idea that men could use a female bathroom. Should it be the case, if this bill passes, that members of the community could not push back on this, it would be of great concern. But, Mr President, we are seeing an ever-increasing push to forget basic ideology and for gender ideology. I thank members of the community who have contacted me in relation to this bill. It has been raised with me that there has been a lack of public scrutiny around this bill. Mr President, quite frankly, I think that's evidenced by the rate at which this government is trying to ram this legislation through the parliament. I will say that many within the religious community have concerns around this legislation. Some of the concerns that have been raised with me include a lack of clarity on the role of teachers within the legislation. There is a concern that if teachers are not equated with parents within the bill, the individual conversations with students at religious schools who are struggling with genuine gender confusion could no longer be protected conversations that had been had in good faith. that the religious exemptions appear to only apply in general terms and not to individual or small group conversations within religious schools. For example, while a school's student code of conduct may hold a position in line with their biblical worldview regarding sexuality, their schools could potentially be limited in their ability to provide individual support for students to aid them in compliance with such a code. That the bill appears to promote an affirmation-only approach to conversations about gender and sexuality. There are queries as to whether religious schools will not be protected for expressing a biblical viewpoint of sexuality, which may be in direct contradiction to taking an affirmation approach. Concerns have been raised with me about the reduction of freedom for anyone to have a different opinion without fear of retribution. Someone rightly put to me that an unintended consequence of this bill is that those who are wanting to talk to their support network may no longer be able to do so. Concerns have been raised with me about the impact on grandparents being able to speak freely with their grandchildren without fear. Concerns have also been raised about even if an adult consents, it is still an offence. We are taking away personal autonomy and choice. Consenting adults should be able to work these issues through. Under this bill, a person commits an offence if they provide or deliver a conversion practice to an individual with the intention of changing or suppressing the individual's sexual orientation or gender identity, and that causes serious harm to the individual. Serious harm in this bill means harm that endangers a person's life or harm that is substantial. It is my view that this bill presents issues with establishing clear causation. The question of but for the behaviour set out in Clause 1A, would the harm have occurred? With that in mind, I indicate that I will be moving an amendment to clearly establish a requirement for causation. In my proposed amendment, which will be Amendment number 1, Henderson 1, a conversion practice needs to have been the sole cause of the harm or have substantially contributed to the harm. This amendment is modelled off the definition of cause provided for in the Criminal Law Consolidation Act. I believe that this is a common sense proposal. In light of the committee the Honourable Frank Pangello had sought to establish about gender dysphoria and gender affirming care, I had the opportunity to hear about the experience of parents of children who were seeking medical assistance and gender affirming care. Concerns were raised with me about the ability for parents to have a voice in this process. I also had the opportunity to hear from people who had detransitioned and the long-term impact this has had on them. These are important conversations to be had. The Deputy Premier has indicated in her second reading that parents are not prevented from being able to have challenging discussions or provide guidance about these matters with their children, and such a parents-child discussion is not captured by this bill. I indicate that I will be moving a number of amendments to better safeguard this protection. Amendment number 2, Henderson 1, Amendment number 3, Henderson 1, Amendment number 4, Henderson 1, Amendment number 5, Henderson 1, and Amendment number 6, Henderson 1 seek to address this. I firmly believe that no matter how old a child is, a parent will always be their parent. This means that parents should be able to have open and honest conversations with their children regardless of their age. Therefore, I will be proposing an amendment to replace the word child with individual to ensure that parents can continue to fulfil their parental responsibilities even after their child turns 18. Clause 4.3 sets out what a conversion practice does not include. In this clause, an example is provided for parents discussing or providing guidance on matters relating to sexual orientation, gender identity, sexual activity or religion with their children. I will be moving an amendment, Amendment number 5, Henderson 1, to make this an explicit exemption within the bill to ensure clarity for parents rather than it being provided as an example. My proposed amendment also provides that an exemption for a parent of an individual where the individual is a child under 18 years of age exercising any powers and responsibilities as a parent of the child. It is my firm view that the Parliament should not be intervening in a parent's ability to parent or shape their family values. Amendment number 6, Henderson 1, is consequential to Amendment 5, as it removes the example provided, as it would be better safeguarded in the legislation should that amendment be successful. I believe these amendments are common sense and seek to ensure that parents can continue to have these conversations with their children, no matter their age. I note that the offences set out in the bill apply irrespective of whether consent is given by the individual or if the individual lacks legal capacity, a parent, guardian or other person who has decision-making authority for the individual. I understand that the Honourable Nicola Centofanti will be moving a number of amendments to address this and indicate that I will be supporting these amendments. I believe it is important for medical practitioners to be safeguarded to be able to do their job without fear of falling foul of this legislation should they refuse to provide puberty blockers or propose an alternative viewpoint to their patient other than an affirmation approach. I believe that the amendments proposed by the Honourable Nicola Centofanti better achieve this and indicate that I will be supporting them. I indicate that I will be supporting the amendment in the name of the Honourable Dennis Hood, which seeks to add the requirement for a conversion practice to have been delivered to the individual outside of South Australia and that the conversion practice cause serious harm to the individual. Currently, under the proposed bill, the individual ought to only have taken or arranged for an individual to be taken from SA with the intention that a conversion practice be delivered or provided to the individual outside of South Australia or engaged a person outside South Australia to provide or deliver a conversion practice to the individual in South Australia. I indicate that I'll be supporting amendments in the name of the Honourable Frank Pangello, particularly draw attention to his amendments that are looking to ensure that this cannot apply retrospectively. I indicate that I will not be supporting amendments in the name of the Honourable Tammy Franks and the Honourable Rob Sims. I'm sure that is a great surprise. It has been put to me that this bill is a solution looking for a problem, and I tend to agree, Mr Acting Chair. The notion that government should, Mr Acting Chair, it is the notion that government should interfere with parental guidance, even if it comes to adult children, that undermines the autonomy of the family unit and the fundamental principle of freedom in a liberal democracy. Government intrusion into such a private realm is a serious infringement of such personal liberty. We must acknowledge that parents have a unique understanding of their child's needs, strengths and challenges. It is not for us as a parliament to tell parents what conversations they can and they cannot have around their dinner table. For this reason, among many others, I will be opposing this bill. And with that, I conclude my remarks.